Early case assessments done right can help clients get great results and minimize litigation costs. Please welcome Tony Rospert.
Early case assessments are a front-end investment that you can make in the litigation to proactively deliver consistent, comprehensive, and a disciplined approach to project management. If done right, they allow you to maximize the cost effectiveness of litigation and deliver results. Some of the big goals of early case assessment is that it allows you to control legal cost. When you have an overall goal in mind from the onset of the litigation, you can streamline the litigation projects and tasks to achieve that goal, ultimately reducing cost. It also improves communication and transparency. Having a strategy on the front end allows you to communicate with your clients and business and other stakeholders within your client's organization. Again, when you have that overarching goal and a plan to execute it on, everyone knows where you're rowing and you're heading in the same direction. Finally, there's empirical evidence that shows that early case assessments achieve better measurable results. Companies that have implemented early case assessment programs have reduced their risk and lowered the cost of their litigation significantly. They've also achieved better results in requiring their outside counsel to engage in early case assessments. So let's talk about where we're heading over the next. Let's talk about where we're heading over the next 5 minutes or 15 minutes. We're going to first dive into the benefits of an early case assessment and the critical components of an early case assessment, and then we'll wrap up with what we're doing at Thompson Hine to achieve the results and create tools that allow our litigators to do a better job of performing early case assessments. So let's start first on what is an early case assessment. I think this definition does a nice job of crystallizing exactly what an early case assessment is, but I want to focus your attention on one word, and that's proactive. If you take nothing else away from my presentation this morning, if you remember that early case assessments allow you to proactively manage litigation, then I will have done my job. So why are early case assessments important? And I think what early case assessments do is they force you to determine at the very beginning of a case, what are you trying to accomplish? When you begin with the end in mind and work backwards from that goal, you can set forth your plan and execute on it. This goes to the second point. You should never go into litigation without having a written plan, a written formalized plan. The back of the napkin analysis is not going to work anymore. Having a clear plan that everybody can execute on is critically important. The next point is the 80-60 rule. And what the 80-60 rule stands for is that in the first 60 days of litigation, you're going to learn everything you need to know about, 80% of everything you're going to need to know about the case. This is important because you should memorialize it. Memorialize what you've learned on the front end, and that can then be used and passed on to members of your team and to your client to say, here are the critical facts. Here's the plan that we're going to execute. Get in line and let's go to it. It's also important because it allows you to stay ahead of opposing counsel. When you front load the case and you have a strategy in place, you create a foundation at the onset of litigation to allow you to make strategic decisions as you progress in the case. So let's dig into a little deeper on the benefits of early case assessments. The first, again, is that word proactive. An early case assessment allows you to be proactive. It does this by ensuring that you're leveraging the right resources to achieve the goals you've set forth in the case. Do you have the right people in place to execute your plan? Or could this case be better staffed and still allow you to achieve your goals? For example, you may have a very document-intensive case. Do you really need 3 associates, or would it be more cost-effective to have some contract attorneys involved? Again, lower cost and reduce the cost, but still achieve your goals. Again, an early case assessment allows you to have that conversation with your client. The next point is it avoids cobbling together strategies dictated by the other side and being reactive. When you have a clear plan in an early case assessment, you can control the process and you can control the result. So it's critically important to have this plan in place on the front end to avoid being reactive. And I want you to take a step back and think like a plaintiff's attorney just for a moment. And that is, plaintiff's attorneys do a good job of looking at issues on the front end. And that's because the contingency fee arrangement forces them to deal with the structural issues and weaknesses of their case, because ultimately that affects their back pocket from how they're paid. So they do a nice job on the front end, and I think that's one thing we might be able to learn from them. As we talked about, early case assessments also reduce cost. And there's two big points of reducing cost: the discovery and trial. Trial costs are reduced because you figure out those cases that are really worth trying and try to resolve the cases that may cut against you. It also reduces discovery costs because a proactive early case assessment plan you can implement a more focused, streamlined approach to discovery. Again, you're being proactive in the type of information that you're seeking and what you're trying to keep the other side from getting at and negotiating for proportionality. Early case assessments also reduce risk. And what I mean by risk here are the unanticipated surprises further on in the case. These unanticipated surprises really drive up the cost of litigation. It's all happened to us. We find a new document, we learn a new fact, and there's this flurry of activity. How do we deal with it? If you're doing an early case assessment correctly, you're bringing in as much information on the front end, and the goal there is to avoid those unanticipated surprises. Get as much information at the onset. The second point is confront weaknesses. And I think this is an early case assessment is a safe context for you to discuss the weaknesses, particularly with business people. They may feel very strongly about the contract they negotiated, but by putting this in an early case assessment, discussing the weaknesses of your client's position, and then talking about how you can overcome those weaknesses, again, as a safe context, the early case assessment allows you to do that without undermining your credibility or the credibility of the business people. Early case assessments also drive better results. As the information I put up there earlier showed, companies that have implemented early case assessment programs have been able to resolve their cases earlier by conducting a cost-benefit analysis in their early case assessment program. But let me be clear, an early case assessment plan is not a plan to settle every case. Instead, an early case assessment allows you to separate the wheat from the chaff. There's some cases that should be settled, and you should try to settle early. But then there's those other cases that we as litigators love. Those are the ones where we roll up our sleeves and say, we're going to win at all cost approach. Well, that doesn't mean we aren't looking at settlement further down the line, but it's critically important to us as litigators to be able to really roll up our sleeves and get at it. And an early case assessment allows us to do that. The last benefit here is measurable outcomes, and I think this is particularly important for in-house counsel, because an early case assessment creates a framework for measuring the value of your outside legal spend. If you require an early case assessment of your outside counsel, you're getting a deliverable that says, here's what we're going to do, here's how we're going to do it, and here's the cost that we're going to do it within. Thus, when the case is over, you can objectively look at whether your outside counsel delivered on their promises in a timely, cost-effective manner. This also allows you to measure your outside counsel against other outside counsel. Who has delivered the most value, and who said what they were going to do in the early case assessment. So let's talk next about the critical components of an early case assessment. What I'm talking about here is your early case assessment memorandum, the deliverable that you're creating. There are 5 key areas that any good early case assessment memorandum should have in it. The first is the background of the dispute. The second is the team, the key facts, the law, and the heart of it, the playbook. So critical component 1 is the background of the dispute. This is the executive summary. This is the information that you can share with other higher up stakeholders in the company that may not need to be in the weeds. One of the key things here is to identify risk. Where are the risks in this case, not only from an evidentiary standpoint, but also from a business perspective? Is there reputational risk? Is there business interruption? What is it going to take to try this case? How much resources are going to have to be diverted from your business people in order to get this case ready for trial? They're going to have to help with document collection, prepare for depositions, give trial testimony. This is the time to discuss that. The other is the ongoing business relationships. What if you've been sued by your largest customer? How will your analysis change? How will that impact the case? This is the time to discuss that. The second is the team. Who is the team that's going to get you to the point of winning this case and achieving your goals? And again, this is the time frame to talk about whether there's a better staffing model or a more flexible model that allows you to cost effectively still achieve your goals. The third point is the key facts, and this really goes to that 80-60 rule I was talking about earlier. Again, in the first 60 days, you're going to learn 80% of everything you're going to need to know about the case. It's important to memorialize what you've learned. But more importantly, it's critical to outline what you haven't learned and identify gaps in your knowledge. What do you still need to find out? Who do you still need to interview? What types of documents do you still need to collect in order to make your case? The next is the legal issues. This is where you're doing your initial research on the claims that have been brought to determine, does this case have merit, even if you're bringing the claims or you're defending the claims. Ultimately, what you're trying to answer, again, is this a case that we should resolve early? Does it have merit? And if it does have merit, how do we best defend it or how do we best prosecute it? Another important thing here is to evaluate damages. And why is evaluating damages important at this stage? Because when you outline your best and worst case scenarios, that informs your cost-benefit analysis in your litigation strategy and your settlement strategy. It's also important here to talk about experts. I'm a firm believer in getting experts involved early, but oftentimes clients push back because experts cost a lot of money. And one of the things we probably fail to do is put the need for expert testimony in context. What I think the early case assessment does a really nice job of doing is putting the need for expert testimony into context and how that fits into your overall strategy of achieving your goals. The next is the real heart of the early case assessment, and that is the playbook. Any good early case assessment begins with a budget. Estimating how much this is going to cost and where to dial that back in order to still achieve your goals really informs the litigation and settlement plan. Having that budget and scoping it out, when those costs are going to hit, and why certain tasks and projects are important to your overall strategy allows you to have that assessment and discussion with your clients. The second part of the playbook is a litigation plan. And what I like to do in this section of the early case assessment is if sitting here 60 days out from the case, what is my opening statement going to sound like? What are the themes and strategies that I'm going to hit on? I can then go from there and talk about the anticipated discovery that I'm going to need in order to establish those themes. And this then allows me to conduct the cost-benefit analysis and decision tree that allows you to determine what path to go down in your strategy. The last is the settlement strategy and settlement analysis. And really what you're trying to do in this part of the early case assessment is identify the pressure points in the case and how to best leverage them. Where are the opportune times to try to resolve this matter, and what can we do to put as much pressure on that particular point in time in order to achieve it? So I want to talk now about what Thompson Hine is doing in building a toolkit to help our litigators perform early case assessments. I'll acknowledge that early case assessments are not a new concept, nor are they rocket science. But what we're doing is integrating them into our budget creation and monitoring software, and then creating a toolkit that allows us to better perform our functions in creating early case assessments. So let's talk about some of the tools in our toolkit. The first is, and the most important, is our early case assessment checklist. We use this as, it's a comprehensive document that allows us to go into our initial client meetings and ask the right questions to make sure that we're gathering the right information. Again, this serves as an agenda for our initial meetings. What's cool about it is it's also connected to model documents. So if we're talking about legal hold notices or e-discovery or a staffing, we can connect to a model legal hold or model ESI protocol. So these first two really allow us to effectively collect the information that we need. The next thing we do is we put it into a template to scope out the project. And the goal of this is the one pager that says, here's our goal, here's how we're going to do it, and here's the scope that we're going to do it in. We then, once we have collected the information, know what the scope of the case is going to be, we can put it into our proprietary budgeting software. When we set out to create this software, we were looking for a TurboTax of legal budgets, and we actually brought in outside programmers to help us build this. What we do is when we can take this information and load it into a budget monitoring system and track how we're doing against budget. But for early case assessment purposes, this is the document that we present to our clients to say, here's what it's going to cost to achieve your goals. So now that we've collected the information, know our budget, we then begin to draft our early case assessment memorandum. We have this template that allows us to address those 5 critical components that we discussed earlier. And again, this is the deliverable that we present to our clients. Finally, we have an updated action item checklist. And the goal of this is to make sure everyone's on task and that no one's going off the reservation and engaging in tasks that are not going to reach our overall goal. So what are the big takeaways? Remember the 80-60 rule. Memorialize what you've learned in the first 60 days that can then be used as a strategic guideline and foundation for the rest of your case. Be proactive. When you control the process, you can control the result. It's also important, however, that early case assessments should be flexible. This shouldn't just be something that you do early on in the case and then put it on a shelf. It should be a living document that continues to evolve as the case evolves. Lastly, you demonstrate value to your clients by engaging in the early case assessment analysis, and you also, as inside counsel, can measure the value of your outside spend by forcing your outside counsel to engage in this process. I want to end with a favorite quote of mine, and the quote is from Mike Babcock, who now coaches the Toronto Maple Leafs, and he says, "Pressure is an interesting thing. You can either accept it or apply it." I believe that doing an early case assessment right allows you to proactively put pressure on the other side and achieve the results that you're looking for. Thank you.